So when judges describe the facts of a case in the form of an evocative narrative, they often include colorful details, like we already discussed with Gorsuch's Western world opinion, that make for a better story, a more compelling and engaging one, but that just aren't relevant for legal purposes. So the most accurate and neutral telling of the facts, the one that includes only legally material details, is just unlikely to make for the most appealing story. So that this means that when judges do aim to write effective narratives, they often include or amplify legally irrelevant details. They also portray litigants as characters in stories, so protagonists or heroes on the one side and antagonists or villains on the other. And these moves, at least some of the time, make for an opinion that isn't particularly legally transparent or efficient, as we talked about in the haunted house case. And they might not give the best guidance to subsequent judges and other readers who then have to do the work for themselves of figuring out which details were included for aesthetic purposes only and which the court found legally material.
Welcome to Emphasis Added, a podcast by the Houston Law Review, where we highlight legal issues with prominent lawyers and discuss the study and practice of law. I'm your host, Kevin Donovan. I'm joined here today with Professor Nina Varsava to talk about her forthcoming article with the Houston Law Review, Professional Irresponsibility and Judicial Opinions. Welcome to the show, Nina.
Thanks a lot, Kevin. Thanks for having me.
Great to have you. And just to cover a little bit of your background on the academic side, I know you cover areas, your research covers areas like civil procedure, courts and judicial decision making, ethics and professional responsibility, and the legal and medical context. And I thought an interesting thing I read about you is you employ both philosophical and empirical methods to study these areas. So we often ask guests about their background and how they got to where they are. So I'm particularly interested about that in your instance. So first, I'd love to know, where did you grow up? And did you have any early influences that made you interested in law?
Yeah, I think that I have a pretty unusual background for a U.S. law professor. I'm from Canada. I grew up on the far east coast of Canada in St. John's, Newfoundland.
Okay.
An island in the Atlantic Ocean. I didn't know any lawyers growing up. I didn't have any family members who had gone to law school. Either my immediate or extended family still don't, as far as I know. And so I always had a vague sense that a career in law would suit me well, but I knew very little about what being a lawyer involved, shockingly little really, until I went to law school.
Yeah, but you didn't go to law school right away, right? So it looked like you've had an incredible run with academia leading up to law school. So you had a bachelor's and master's in English language and literature. And before you went to law school, it looked like you were well on your way towards an interdisciplinary PhD concentrating in ethics. So what drove you to law school and to start a career in law in the first place?
Yeah, it's a long and winding story, so I'm going to try to give you the shortest version possible.
Okay.
So in the early part of my PhD, I focused on issues related to language, rhetoric, and practical ethics. And I became increasingly interested and drawn to questions about law, especially questions at the intersection of law and rhetoric and law and ethics. And at some point, it became apparent to me that I couldn't pursue the questions that I was most interested in without some expertise in law. So naturally, I started reading legal scholarship and cases. I even took a law course I was doing my PhD at Stanford, and I had the opportunity to take a class there and really enjoyed it. And then eventually just decided to take the plunge and go to law school. And fortunately, I had my faculty advisors and committee members were supportive of the idea, given my research interests. And they stuck with me through that, even though I went to law school on the other side of the country. And then after graduating from law school, I finished my dissertation and then worked as a judicial clerk before starting in my current faculty position.
Okay. And when I read your article, I didn't know what your background was yet or anything. And so I found it really interesting. I mean, it makes your topic and the way you write about it makes just like so much more sense, knowing that you've had this language and literature background, this concentration in ethics. And so now hearing, how that kind of drove you into law explains a lot. So I think that's great. And so I'd love to dive into your article now because I think it's really fascinating, and we're really happy to have you publishing with us. And so I'd like to talk about it, professional irresponsibility and judicial opinions. But I think for some of our listeners, it might first be good to just kind of go over the basics here. And I think the most basic part of this article might be, what are judicial opinions and why are they so important?
Yes, that's a great place to start. So judicial opinions are the texts that judges write and the courts issue alongside their decisions in legal cases. So a judicial opinion articulates basically the reasons why the judges reached the conclusion that they did in a legal dispute. And judicial opinions are important for a variety of reasons, which I discuss in detail in the paper. I won't get into all of them here, but one major reason that opinions are important is related to the system of precedent. So as all law students know, in the US, we have a robust doctrine of precedent, and this means that judges follow previously decided cases and they're under some obligation to do so. So judicial opinions make this possible or facilitate that enterprise because they serve as windows into how previous courts decided cases. And another related reason that judicial opinions are important is that they inform others, not just judges, but lawyers, the legal community, and the public about the state of the law, about how judges are interpreting and applying the law. And so they give people a sense of how disputes are likely to be resolved going forward. This is, of course, also related to the idea of precedent that I referred to already. So opinions in this sense serve an instructional role. They provide people with instructions on how to comply with the law.
And precedent, something you've also written about in multiple other articles. So if none of our listeners have ever read any of Nina's other articles, definitely suggest checking them out. One of them we'll talk about a little bit more in depth later, but I won't give that away yet. I'll keep that suspenseful because podcasts, no one says that podcasts can't be suspenseful, but we will see about judicial opinions here. And so we talked about what judicial opinions are, but a big thing you get into in your article is how judges are advised to write. And so curious, what is that current advisement like for judges?
Yeah, so there's a large body of literature that discusses legal writing in general and judicial writing in particular from multiple angles. And there's some heterogeneity, of course, in that guidance, but there's a substantial segment of literature that advises judges to write in an engaging and aesthetically pleasing style. So the idea is that readers will be more likely to read opinions and will appreciate them more if they're written in a conversational, personal style, one that uses narrative and storytelling techniques as opposed to a technical or bureaucratic or legalistic one.
And I think in that aura, part of it, a quote from your article, you cite to Ross Guberman, who's the president of Legal Writing Pro LLC, author of multiple books on legal writing. And something that he says is that judges should not institutionalize or sterilize their voices, but should let their writing live and breathe instead through a sympathetic style and a strong dramatic arc. And then later you kind of go on to say that Guberman kind of states, don't be afraid to play storyteller. And I think that is a very kind of at the heart of what you're talking about as this current contemporary judicial advice to judges on how to write. And so, but I'm curious, in your article, you talk about the need to acknowledge different viewpoints in judicial opinions, and you seem to mirror that preference in your article as well. You would acknowledge some of the pros, or at least the arguments that these contemporary legal writing professionals are advising judges to do. And so I'm curious, at least maybe from that standpoint, why are judges advised to write this way? And are there any pros, in your opinion, to this writing style?
Yes. So as you noted, I'm critical of this kind of advice, but I do think that there are some highly intuitive reasons why we might favor opinions that read more like short stories than like technical manuals or statutes. And I try to acknowledge these and give them all of the reasons on that side full consideration in the article, because I think it's a difficult question and that there are good reasons on both sides. So I won't go into all of them, but one obvious reason that might come to mind is pleasure. So short stories are more pleasurable to read than technical manuals or bureaucratic writing. So we read short stories just for fun. After all, we don't read technical writing or legislation for fun, not most of us anyway. So to take an example I discuss in the article, which maybe we'll talk in more depth about later on, would you rather read a story about a haunted house employee who falls tragically down an elevator shaft? Or would you rather read about the technical legal dispute between insurance companies that involves obscure areas of contract law, which the haunted house incident gave rise to? Most of us would rather read about that haunted house story than the details of the contract and insurance law.
And I do you have an incredible quote from that case that I do plan on talking about a little bit later. So stay tuned, listeners. And yeah, I mean, I think for me as a law student, right, especially in the beginning of law school, like those were the only cases I was looking for. I was like, why do my casebook authors not only have these cases? But I mean, I'm going on to my third year of law school, and so I have figured out legal writing a little bit more, and can obviously see a lot of the benefits to what you're advocating for in your article. And I think for me, it's like a bit of a balancing test here. And so maybe some of your solutions that you advise kind of strike that balance. And so we'll be curious to talk about that later. But, curious now, what motivated you to write this article in the first place?
Yeah, so what I want to do with this article is to draw attention to the ethical stakes of the stylistic choices that judges make when they write opinions, and that I think that we should keep in mind when evaluating the merit of different approaches to judicial writing. And this might not be obvious when we're talking about something like writing style. It might not be so obvious that there are important ethical stakes involved, especially because the ethics of judicial writing, I think, are very different from the ethics of storytelling and writing style in other contexts. So I make the case that we can't separate the question of what makes for well-written judicial opinions from considerations about the integrity of the judicial role and the legitimacy of the adjudicative process. But again, I don't want to suggest that the calculus is easier or one-sided here, even though I'm critical of a lot of the existing commentary. My aim really is to draw attention to the costs of this kind of attractive writing that I think have been overlooked or underestimated in the related literature, and also by judges themselves. And also to suggest that the benefits of this approach to writing, which I think are real, have maybe been exaggerated.
And I feel like judges, I mean, they must be aware of this. I know in another article, you cite some empirical data that we'll talk about later. And you can see that there are some judges that seem to conform much more closely with the writing style that you're advocating for in your article. And so it makes me wonder, why would a judge conform to this more narrative, emotional writing style in the first place? I mean, what's at stake for the judges, or what's to benefit from conforming here?
Yes, so different judges take different approaches to writing style, and some do already embrace the kind of style that I'm arguing for. I think that there are a few reasons why a judge might aim for a more engaging, entertaining, and aesthetically pleasing style. So, first, a judge might genuinely care about reaching the public and might believe that they would alienate the public if they wrote in a dull, technical manner. But I think the judges who aim for a colorful, evocative style generally do so to attract attention to themselves and not necessarily to the law. So, adopting this kind of style and standing out stylistically does seem to help judges make a name for themselves. It attracts the attention of the legal community and the news media. So a flashy, distinctive personal style can help with the visibility, popularity, and reputation of judges, and in turn with career advancement.
And I think you mentioned this in your article, maybe not in this context, but it seems like Guberman, in a quote from your article, kind of lends credence to what you're saying here. He says, the celebrity-driven legal culture in the United States spurs the nation's most ambitious judges to perfect their craft and to develop a powerful voice. And so I feel like what you're saying there, that it is almost maybe more of an individually motivated way to, kind of advance yourself in the public light that way. I think that, kind of says it right there, in a way. But like, we have so many rules, we have so many laws about lawyering, about being judges. And so it makes me wonder, are there any requirements behind how judges write?
There are very few requirements, formal legal requirements, at least in the US. So some courts do have rules, for example, that prohibit judges from attacking one another in opinions. So these basically mandate some degree of collegiality in opinions. And courts, of course, follow certain citation and labeling conventions. But judges generally have discretion to include whatever they want in their opinions and to write in whatever style they like. There are, of course, norms that judges generally follow in their opinion writing, so that we have some notion of the genre of opinion writing and consistency across opinions, but these norms leave a lot of room for personal discretion and variation across judges.
And in your article, you say, in defense of her own writing style, Justice Kagan has observed that there's no rule against fun in opinions, which of course is true. So I guess you can have fun, so, right now at least. And so very, very interesting. And I guess, I'd love to dive into the professional irresponsibility side of your article now and kind of talk about what is an example of a professionally irresponsible opinion. So I if you'd like, I can cite, because I know you've already talked about Western World v. Markell, right? The Neil Gorsuch opinion. And so some things from your article that I thought was really interesting. This citation from that opinion we were mentioning earlier: haunted houses may be full of ghosts, goblins, and guillotines, but it's their more prosaic features that pose the real danger. Tyler Hodges found that out when he plummeted down an elevator shaft. But as these things go, this case no longer involves Mr. Hodges. But then continues to go on to describe Mr. Hodges' experience in an insurance dispute. And so, it's just, that's just so fascinating. And is this something that's common? Do you see this in a lot of opinions, this sort of writing?
We see this in a lot of opinions from some judges, and Gorsuch is one of them. And I don't mean to pick on Gorsuch, but he has many gems like this, and the haunted house incident is a particularly striking one. So I discuss a lot of different examples in the paper from various courts, state courts, federal courts, mainly in the US, but I take some examples from a Canadian provincial court as well. And the one that you mentioned is by Gorsuch when he served as a judge for the 10th Circuit Court of Appeals in a dispute, as you noted, between insurance companies. So Gorsuch makes a great deal out of the background incident that gave rise to the insurance dispute. The insurance dispute itself is dry and technical, and he does get into that, but he spends a lot of the opening of the opinion just describing the events that led up to the insurance dispute, which are mostly irrelevant now at this point in the proceedings. But an employee at a haunted house had fallen 20 feet down an elevator shaft, and Gorsuch narrates this incident in detail, which of course the incident does make for an entertaining and memorable narrative. And a lot of articles picked up on this. The news media covered this article quite a bit, mostly just talking about the stylistic features and the narration of the haunted house incident rather than the actual legal issues at stake.
And that seems to me to be kind of contrary to the advice, or at least the pros to the advice. One of the biggest pros that I think is probably the most influential is that opinions should be clear, short, and direct. And I think clear and short, especially, I mean, is this not counterintuitive to add these sorts of things in?
Yeah, so Gorsuch spends a lot of the opinion just describing this event. I did a word count, and I think it's about, I say exactly what it is in the paper, but I think it's about 10% of the opinion. It's a pretty short opinion overall. So to spend a couple paragraphs discussing this incident is a lot. So you might think that it's clear. The narration of the story is very clear. We have a good sense of what's going on or what happened. But on the other hand, it doesn't really illuminate the legal issues. You have to read on and actually wade through some much drier content in order to understand the legal issues involved here. So you might think that, well, this draws you into the opinion or something like that and leads you to read the rest. But in reality, if you're reading this opinion for the legal content, you have incentives already to read the doctrinal parts. I don't know if you need this kind of introductory material. And for those who might be reading the opinion for fun, I doubt there's many people who read opinions for fun, but for those who do, they probably won't have much need to go on past the narration of the accident.
People don't read judicial opinions for fun.
I think a few people do.
I had never, I wouldn't even have known where to find a judicial opinion before I went to law school. But and not to sharpshoot Neil Gorsuch, you also do, you mentioned other renowned judges, and we won't get into all their pieces or anything, but just for our listeners, within the article and your other article that's more focused on Neil Gorsuch, you talk about Justice Scalia, Cardozo, Justice Kagan, a slew of, I think, learned hands in there, things that, like, law students especially, like, these are people that you dress up for as Halloween. At least I might have once. And so I mean, I think it's really interesting, right, that your article is really pushing back against the cultural norm. But you have a lot of good reasons for why, and I think it's very interesting. It's very educational for, perhaps this view that we kind of lose in law school and stuff. But to get a little bit more on the professional irresponsibility side, what is it about this opinion writing style that is professionally irresponsible?
Yeah, there's a lot to say here. So I'll have to direct listeners to the article for the full argument, but I'll mention a few points. So basically, I argue that the kind of evocative and lively writing style that judges are encouraged to adopt comes with considerable risks, and that these risks outweigh the possible benefits of this approach to writing. And these risks mainly have to do with transparency and guidance, and also fairness and the appearance of fairness. So when judges describe the facts of a case in the form of an evocative narrative, they often include colorful details, like we already discussed with Gorsuch's Western World opinion, that make for a better story, a more compelling and engaging one, but that just aren't relevant for legal purposes. And so the most accurate and neutral telling of the facts, the one that includes only legally material details, is just unlikely to make for the most appealing story. So that this means that when judges do aim to write effective narratives, they often include or amplify legally irrelevant details. They also portray litigants as characters in stories, so protagonists or heroes on the one side and antagonists or villains on the other. And these moves, at least some of the time, make for an opinion that isn't particularly legally transparent or efficient, as we talked about in the haunted house case. And they might not give the best guidance to subsequent judges and other readers, who then have to do the work for themselves of figuring out which details were included for aesthetic purposes only, and which the court found legally material. The court deciding the original case is in the best position to make those determinations. And so when a judge tries to craft an engaging story using evocative language, it often means sending unnecessarily ambiguous or misleading messages. So one cost then is to the guidance and instructive value of opinions. Another is to fairness and the appearance of fairness. So if we think that judges have duties as part of the judicial role to give litigants a fair adjudicative process, and not only that, but also one that comes across as fair, then we should be wary of opinions that appeal to our weakness for narrative and literary devices.
Before we continue, a special thanks to our sponsor, Vincent & Elkins, a global law firm with 11 offices and more than 700 lawyers committed to excellence in serving and advising its sophisticated clients in industries such as energy, finance, technology, real estate, media, and beyond. V&E lawyers are also proud to support pro bono clients across their communities. To help clients navigate complex areas of law, V&E hires the best and brightest law students and lawyers, valuing diverse perspectives and backgrounds. Visit www.velaw.com to learn more about V&E's Summer Associate Program and hiring opportunities. Start your success story at Vincent & Elkins.
And so, Nina, you mention in your article the appearance of impartiality as part of the ABA's Code of Judicial Conduct. So I think that's kind of a lot of what you were just saying there, that why it's so important to acknowledge both arguments. I think on the other side of things, just another quote from your article that I thought was really interesting, that's kind of portrays the contemporary view. You cite to the late Patricia Wald of the DC Circuit Court of Appeals when she remarks that the facts can, and indeed must, be retold to cast a party as an innocent victim or an undeserving malefactor, to tow the storyline into a safe harbor of whatever principles of law the author thinks should control the case. And it just, that sort of advice, it just kind of leads me to, like, are these framing arguments in persuasion of this current style, is it more like manipulation than promoting faith in the judiciary?
There's a lot to that question, so let me try to break it down a bit in my response. So a persuasive style or an approach to writing that tries to be persuasive can certainly be manipulative. And Patricia Wald there seems to be alluding to that possibility and even saying that it might be necessary to manipulate the audience, especially since legal cases are often hard and often conclusions are not clear and obvious. So, for example, an opinion might gloss over certain facts that would make the court's argument for its judgment weaker, or an opinion might appeal to certain common biases to make its argument seem stronger than it actually is. Nevertheless, this kind of manipulation might actually promote faith in the judiciary. So I make a strong distinction in the article between actual fairness and legitimacy on the one side and perceived fairness and legitimacy on the other. So this kind of legitimacy is often called sociological legitimacy in the scholarly literature. And I think that commentators on this topic often give too much weight to sociological or perceived legitimacy. It's that kind of legitimacy certainly matters, but in my view, actual legitimacy matters more and should take priority in normative analyses. So if judges are able to write in such a way that would trick readers into thinking that decisions are legitimate when they're actually unfair, I don't think that's a good thing. I think that actual legitimacy is more important than perceived legitimacy, and that first and foremost, adjudication should be actually legitimate. Once we have that, we can worry about how to make legitimate decisions also appear to be legitimate.
Okay. And I guess, we talked about like the argument for accessibility, but I mean, I guess as I've admitted to at least, I hadn't really ever read a judicial opinion prior to law school. I mean, do lay people read judicial opinions? Is there any statistical data on this?
There are some studies that have tried to test whether people read opinions and whether people are generally aware of judicial decisions. And I quote some of that literature in my article. Some of it might be somewhat outdated, so maybe it's worth running a new study. But the evidence seems to suggest that people do not read judicial opinions and actually have very little awareness or interest in judicial decisions. So that seems to be where the weight of the evidence is. And as you mentioned, I don't think that's particularly surprising to us. I didn't read until my PhD. I don't think I had ever read a legal decision either.
I mean, I think at least the easiest analysis would be number of Westlaw subscriptions per capita, But I mean, So to talk about the empirical side of things, I'd like to now segue into a different article of yours, but it seems to be influential or to be, some of the similar citations in your current article forthcoming with the Houston Law Review. And that is your article about Neil Gorsuch. And that article was called The Elements of Judicial Style, A Quantitative Guide to Neil Gorsuch's Opinion Writing, published through the NYI Law Review. And so you do this quantitative analysis of Neil Gorsuch. And so, you talk about a lot of trends you find in his opinion writing. So I'm kind of curious, what are some of those trends, and what's an example of, one of these empirical algorithms that you use to analyze these trends?
Yeah, so I conducted this study when Gorsuch was being considered for the Supreme Court because I was surprised by how much of the media coverage of him as a jurist focused on his writing style. So I discovered around that time that reporters had been commenting on his distinctive approach to opinion writing for several years, but there hadn't been any systematic or rigorous studies of his writing. And I wondered if commentators were right that Gorsuch really was a special writer, or if people were just overly influenced by a handful of his opinions. And I also wondered if we could measure Gorsuch's style. So basically, if computer algorithms could pick up on his stylistic tendencies or trends, or if they were too elusive for that. So in general, I found that Gorsuch really is a distinctive writer. He stood out from his peers on the 10th Circuit on most of the stylistic variables I measured. For example, I found that he writes more informally than others, at least according to some basic measurable indicators of informality, like contractions and starting sentences with short conjunctions. I also found that he uses words expressing certainty more than his peers, so words such as obviously, clearly, and surely. In the linguistics literature, these are sometimes called intensifiers. And I tested this because Gorsuch had been criticized for being overly confident and dismissive of others. But as a kind of placebo test, I also examined whether he uses hedges more than others. So these are words expressing hesitancy or doubt or uncertainty, like possibly and maybe. And it turned out that he does use these words a lot more too. So it seems like Gorsuch likes to qualify his assertions in both directions, pointing out when he thinks something is obvious, but also when he's unsure about a point. And for examples of algorithms I use, just to explain the technical aspect a little bit, the algorithms I use to measure certainty and tentativeness are very simple. So I first made a list of terms that represent certainty and another list that signify tentativeness. And I drew on existing literature for this, but also elaborated it for the context I was interested in. So these kinds of lists are sometimes called sentiment dictionaries in the computational linguistics literature. I then used the computer programming language Python and wrote a program which simply scrolls through all of the opinions, looking for instances of these words and counts them up. And because I was interested in frequency of use, I took the number of those terms as a proportion of the total words in the opinion. So that basically controls for opinion length. So then I came up with a frequency for all opinions. I calculated the average for Gorsuch's opinions and compared this number to the number for his colleagues on the 10th Circuit over the same period of time.
And I love this. I love that you went through this because I personally like data. And it's also, having read about your background, it's a synergy almost of your background. You really get kind of that English literature like awareness of these different linguistic tools, and then kind of taking that and mixing it into the legal sphere of things and how the judiciary writes. And so you for our listeners, Nina goes through that at length in that opinion. So absolutely check that out, and we'll put that the link to that opinion in the show notes. But this leads me to a question, kind of now synergizing these two articles. We've talked about, what's kind of at stake for the judiciary here. And it makes me wonder, how influential do you think Neil Gorsuch's theatrical writing style was on his Supreme Court nomination?
Yeah, I can't be sure, of course, but I suspect that Gorsuch's reputation had something to do with his distinctive writing style. He certainly seemed to get more media coverage because of that, and probably wider media coverage. So it seems that he was better known thanks to his approach to writing, at least we can say that. Um, so yeah, maybe I'll stop there to see if you have any follow-ups.
I mean, yeah, in that article, I mean, one of the quotes I took from it was Gorsuch is celebrated as a particularly incisive legal writer with a flair that matches or at least evokes that of Scalia. And so, I mean, Neil Gorsuch was nominated to the Supreme Court by then President Donald Trump in 2017, so a conservative, and it kind of, I suppose, that's where I kind of drew like, all right, it kind of makes sense if you have like those similarities. I mean, let's be honest, there's dozens, maybe hundreds of or more great judges in the United States. I mean, there's just so many good judges. I mean, even if it was we had a judiciary where I suppose they weren't picked that way, like it's just gonna happen, and so. I suppose it makes sense that this sort of, suspensefulness would kind of push you apart from your peers, especially when you look back at Ross Guberman's quote that we kind of have this celebrity culture for the judiciary. And so I just thought that was a really interesting kind of synergy of your two articles. And so I was curious also, did any part of your analysis in the Gorsuch article inspire you to write your forthcoming article with the Houston Law Review?
Maybe in part. So my aim in the Gorsuch essay was purely descriptive rather than normative or prescriptive. But normative considerations are always on my mind, even in my descriptive work. And my research for the previous essay and also some related descriptive work did leave me with a lot of questions. The main one being what makes for a well-written judicial opinion, and why do people think that judges should write like creative writers when the enterprises that judges and creative writers are engaged in are so different with fundamentally different purposes. So this more recent article gave me the opportunity to explore those questions at length.
And to talk about, so we've talked about you exploring these sorts of normative considerations. Now I'd like to talk about and segue into maybe some proposed solutions. And so would love to kind of let our listeners know what do you think, or what is your article going to explore as the best alternatives to the current style guidelines for judicial opinions?
Yeah, in some ways, I think that judges would be better off following the kind of guidance directed at legislative drafters. And so I discuss some of this literature in the paper. For example, don't vary diction. If you mean the same thing, use the same word. And which is just the opposite of what judges are sometimes told, and just the opposite of what creative writers are often told. Probably it's good for creative writers to vary diction, but I question whether we should apply that advice in the judicial writing context. So I think that in general, judges should conform to an even-keeled institutional style and should speak more with one unified voice rather than trying to let their own individual personality shine in their opinions, and maybe refrain from trying to be funny altogether, because sometimes judges pull it off, but I think that there are a lot of potential costs to trying to be witty in opinions, especially since for the litigants, the litigation often isn't a laughing matter, and the stakes there are very high.
So there should be a rule against fun opinions.
I think so.
There you have it.
Sorry, Kagan.
But I mean, I think you draw an incredible point that for whatever reason, I think sometimes, at least in law school, you're kind of removed from, is like there's a lot at stake for these parties to be having, wit and fun. And so I just think that, at the bare minimum, if the absolute advocate for this theatrical style of writing takes anything from your article, I would hope it's at least that awareness and just kind of bringing you back down to earth that, there are two sides to judicial opinions. It's not just judges writing to other judges, writing to lawyers, or to the public, it's to these parties. I'm assuming that's why we pay our tax money to court systems, is to resolve disputes. But you also mention in your article how other countries deal with these issues. So I'm curious, your thoughts on that.
Yeah, I haven't studied judicial writing in other countries in depth, but I have looked a bit to Canada, and I include some discussion of the Canadian system in the article. So Canada doesn't seem to have as much of a celebrity judge culture as we do in the US, as far as I can tell. And I don't think that judges there are as concerned with making names for themselves through their writing style, although there are some exceptions. Canadian opinions seem in general to be more bland and dull stylistically than American ones, and more complex and technical. This is just my own impression based on reading opinions out of both systems. The Canadian system deals with possible problems of accessibility in various ways. So for example, the Supreme Court of Canada employs an executive legal officer whose job it is to communicate with the media about Supreme Court opinions. And the Supreme Court of Canada also, in a more recent initiative, produces something they call cases in brief. So these are short summaries of opinions in reader-friendly language, and they're meant to help a general audience access the legal points in the judicial decision. So they're not official in the sense that they're not precedential like a judicial opinion, but they are in some sense official because they're issued by the Supreme Court as an institution and written by communications staff members. So people can access these summaries on the Supreme Court website, and the court also invites the news media to reproduce the summaries in full. And so the court can reach a broader audience that way beyond just people like me who would be poking around the Supreme Court's website.
And it makes sense now that I hadn't known that when I was reading your article that you were from Eastern Canada, and you talk in your article about some of the Canadian judicial writing, like rules and such. You also talk about French judicial opinions as well. And could you just go into that just a little bit? Because I thought that was, I guess, so you talk about it. You say, for example, they're unsigned, short, and formulaic, leaving little room for judges to exercise stylist discretion. I guess my real question is that the vision that you would set forth for American judicial opinion writing?
No. So I think that commentators often draw a false dichotomy between that kind of clipped, very short, deductive style. So the French opinions are also like written in the form of deductive arguments.
Okay.
And like you say, they're unsigned. And so a lot of commentators who favor the American approach suggest that actually the French approach obscures a lot, so that people don't have any idea what went into the decision. And so those decisions aren't transparent. I don't think we need to choose between the current norms we have in the US and the French system. So I think that we can have opinions that do reveal the real legal reasons that the judges took to justify their decision, but that just aren't written in an evocative or highly narrative style, but a more technical one. And I'm no expert on the French system, but there are some sources I cite in the paper that talk about the French and other systems in depth.
So there is a balance that can be struck.
I think so. I hope so.
I think me too. I think you're definitely very convincing in your article, as to some of these reasons, and so it does sound that way, and I'll be interested. I'll be interested to see what comes of this. And so for our listeners, if you want to hear more about Nina's article, Professional Irresponsibility and Judicial Opinion Writing, her article will be published fall 2021 from the Houston Law Review. So keep an eye out, keep an ear out for that. And again, we'll have some link in the show notes. But for closing questions, there is something you mentioned in your article we haven't talked about yet, and so I have to ask. you mentioned podcasts as a great way to increase legal knowledge for the public outside law school, and you cite to the Strict Scrutiny podcast. And so I have to know, after this episode, is there any likelihood you'll be making maybe an additional string cite to that?
So podcasts, yes, can inform the legal community and the public about legal developments in ways that can be more accessible than judicial opinions themselves. And I think people are increasingly turning to podcasts for this purpose. I cite the Strict Scrutiny podcast in particular in this regard, which is produced by law professors Leah Littman, Melissa Murray, and Kate Shaw. There are several other podcasts that focus more on legal scholarship than judicial decisions, including yours. Felipe Jimenez has a private law podcast. Brian Fry has been producing a podcast called Ipsy Dixit for a number of years. Will Bode has multiple podcasts. I listen to and appreciate all of these. The reason that I highlighted Strict Scrutiny in the article is because it focuses on judicial decisions specifically, and mostly Supreme Court cases, but sometimes decisions from other courts as well. And that podcast discusses opinions as they come out, explaining their implications for a legal and also a general audience. So I think that's a great public service. But I also think it's a great service that you're doing, that other podcasts are doing, to highlight legal scholarship, which sometimes can also get buried and lost. And maybe we shouldn't expect the general public to wade through 80 pages of a law review article either. So it's really nice to be able to summarize and highlight key points in the form of a podcast.
Well, I'm glad I asked you. I'll tell the editors to pull our suggested emphasis added addition to that citation. It makes a lot of sense. We do love, I love all the podcast shout outs though. I think that's great. And it's interesting. I think some of those I hadn't heard of. So it's good to know that there's others out there doing this sort of work. And so for our final question, we've in the past, we've asked our guests, whether or not they're pro or con Oxford comma. You talk in your article about writing rules for how courthouses write. And so if it was up to you, would you require judicial opinions to have the Oxford comma or not?
Yes, I would. Not just judicial opinions. Actually, I think that rule could be universal.
Okay. Yeah, you'll have to tell that to the transactional attorneys, because for whatever reason, transaction lawyers seem to be very anti-Oxford comma, and I'm not sure why, but as an aspiring transaction attorney, I must conform unless there's a well-written article.
What's your
otherwise.
position on it?
I don't want to say I'm Oxford comma apathetic. I'm still open. Still, like all great podcast hosts, you have to be open to different opinions. Thanks so much for being on the show, Nina. It was a pleasure to have you. It was a pleasure to talk to you about your article, and I really look forward to the law review working on it, and for that article coming out in fall 2021.
Thank you so much for having me. Thanks for your interest in my research and for all the work you do in producing this podcast. And I want to also note that for listeners, even though this article is not out yet, it's going to be published in the fall, it is currently available on SSRN, so they can access the most recent draft there. And people should also feel free to email me. I'm happy to send a copy their way.
Perfect. And we'll include a link to that article and to your email in the show notes. So thank you so much, Nina.
Okay. Thanks, Kevin.
Thanks for listening. Emphasis Added is a podcast by the Houston Law Review. If you like what you heard, subscribe to us on YouTube or your favorite podcast app, and follow the Houston Law Review on social media, or check us out on houstonlawreview.org. Till next time.